Their Lordship.
Yes.
Lordship, I beg to mention item number 20 on behalf of Pritam Tafo. He is unable to appear, Lordship. Matter may be adjourned for today, Lordship.
Who is for the respondent?
I have taken consent, Lordship.
Okay. Miss
P. Moyong.
Lana Council submits the conducting council, Mr. E. Tapo, is unable to attend the court due to some personal difficulties. Therefore, praise for adjournment of the matter for
2 weeks, Lordship.
2 weeks. She has also obtained consent from the Lana Council of the other side. In view of the above, let the matter be listed after 2 weeks. Okay.
Obliged, Lordship.
My lord, I beg to mention item number 3. Leading counsel is out of station, so matter may be listed after 4 weeks. I have taken consent from the other side.
Mr.
A. Bonia.
You are for the petitioner.
Yes, lordship. On behalf of O. Modi.
Submits that the leading counsel, Mr. O. Modi, is out of station. Therefore, pray for adjournment of the matter. For how much time?
4 weeks, lordship.
For 4 weeks. He has also obtained consent from the council for the other side. In view of the above, the prayer is allowed. List this matter after 4 weeks.
My lord, I'm board
Most obliged.
number 1. I'm board respondent number 1.
Yeah.
Yes, ma'am.
Okay. Then, second sentence, Mr.
D. Pango.
D.
D. Pango.
Okay. Lana counsel for the respondent has no objection. Okay.
My Lordship, I beg to mention item number 21 on behalf of DSGI M. Kato for respondent. Your Lordship, we have taken consent from the other party. Therefore, this case may be listed after 4 weeks, Your Lordship.
You're for the respondent.
Yes, Lordship.
Miss
Ms. O. Jarang.
Lana counsel appearing on behalf of Mr. M. Kato, Lana DSGI, with the consent of the Lana counsel for the appellant. Praise for listing this matter after
4 weeks, Your Lordship.
4 weeks. The prayer is allowed. List this matter after 4 weeks.
Much obliged, Your Lordship.
My lord, item number 10, my lord.
I think check.
The leading counsel K. Dabu is out of station, my lord. It may be listed after a week. Consent has been sought from the other side as well.
Okay. Mr. Mugam Patil, Lana counsel for the petitioner, with the consent of the Lana counsel for the other side. Praise for listing this matter after
1 week, my lord.
1 week. Okay. Prayer allowed. List this matter after a week.
Much obliged.
May I, Lordship? I beg to mention item number 5. The leading counsel, due to some unforeseen domestic problem, he is out of station. So I have taken consent from the respondent also.
Okay. Similar order, Mr.
H. Atta, I am appearing on behalf of T. Topu, leading counsel of this case.
Appearing on behalf of submits that the leading counsel, Mr. P. Topu, is out of station. Therefore, pray for adjournment of the matter for how much
Your-
time?
After 4 weeks, maybe.
So 4 weeks.
Sir, Your Honor, there is an interim order also.
He has also obtained consent from the land council of the other side. Accordingly, the prayer is allowed. This matter after 4 weeks. Stop the interim order passed earlier shall continue till the next date of listing.
Much obliged.
May I, Your Lordship? I would like to mention item number 13 on behalf of Aringo. Currently, the leading counsel is out of station.
Item
13. Consent has been taken.
Okay, we'll see. This is order matter. We'll see the record and we'll ground the adjournment, but wait for some time. Okay.
Your
Yeah.
I'd like to mention the item number 22, madam, on behalf of Self May.
Yes, what?
That the leading counsel is out of station, so
Out of station?
the time may be.
Which for the other side?
I'm for respondent number one.
One.
Yes.
No objection.
Hmm.
Mr.
Key role है.
Learning Council को Learning Council commits that leading council Mr. L. Parno is out of the station. They have to pray for adjournment. For how much?
2 weeks, man.
2 weeks. 2 weeks, miss. You are miss.
K. Nyorak, I'm
Hmm.
appearing on behalf of N. Dangen.
Learning Council appearing on behalf of Ms. N. Dangan. Learning Council for the respondent has no objection. Accordingly, the prayer is allowed. List this matter after 2 weeks. Okay. Yes.
I beg to mention one unlisted item, Lordship. This matter may be taken up tomorrow.
Tomorrow?
Yes.
Okay. What is this matter about? Otherwise?
This is a criminal revision
Okay.
petition in NIA.
Item number 1.
Well, this petition is for passment of the FIR dated 3/11/2025, which has been laid into Nyapin PS case number 02/2022. Well, the section charge are section 305, theft in dwelling house, 331, house trespass, section 3, subclause 5, common intention. So, well, the gist of the FIR is that 3 juvenile in conflicts with the law were apprehended, who are now aged about 13 years, 12 years, and 10 years.
Okay. What happened thereafter?
Thereafter, this parents of the juveniles
Were they arrested?
apprehended, yes, apprehended and released into the custody of the parents.
Parents, okay.
So now
Then whatever the case is,
it's still in the
what is the status of the
investigation. No charge sheet has been
investigation?
filed
Well, when the FIR was filed?
on 03/11.
11.
Yes. At page number 20. Type copy is at page number 28.
Okay, theft.
Theft. 2 mobile handset as well as case of 3,000.
So record would be necessary.
Lordship, since the it's a settled matter otherwise, Your Lordship. It's, the investigation is still,
Now you obtain instruction, what happened?
okay, Your Lordship.
Otherwise, we can dispose of.
Yes.
Just obtain instruction, confirm that they are the accused involved in the case are juvenile
Yes, Your Lordship.
or no other major persons are involved. And there is, other than this, there is nothing. Okay.
Yes, Your Lordship.
So, call for the record or
We'll
just
call
obtain
for the
instruction?
record, Your Lordship.
Okay. When?
You'll have to. On 8, Your Lordship,
8.
8.
Mr.
Jiriba.
Learning Counsel for the petitioner. Also had Miss Jenny, Learning Additional PP for the state. Stop, para. This is a joint petition filed under section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023 by the informant and
So the
The-
parents of the these juveniles.
parents of the child in conflict with law in connection with Nyapin PS case number 02/2025 under section 305 stroke 331 2 stroke 3 within bracket 5 of BNS. For, not just a minute. Okay, praying for crossing of the FIR dated 3/11/2025, register at Nyapin PS. Okay, bring that way. Call for the scanned copy of the case diary. Okay. List this matter on
Eight.
as prayed for, list this matter on 8.
Yes, Your Lordship.
8 is last
No, it's on Monday, coming Monday, Your Lordship.
or coming Monday. Okay.
Obliged.
Deeply.
Item number 2.
Yeah, my lord.
Yes.
My lord, I'm here, I agree with the order dated 28/10/2025, passed in a missed case number 278 in complaint case number 98 of under section 38/142 of NI Act. Here, the learned judicial magistrate first class has issued a non-bailable warrant against me.
What is wrong about it?
Yes,
What is wrong in it?
Your Honor. Your Honor, I have already filed an appeal in a district and session court here, Your Honor. But during the pendency, this missed case was
Is there any stay?
no appeal is on due to
In the appeal, if there is no any stay order,
yes,
then
Your Honor, on this last 24, there was a hearing on this for the stay order, but
That is
due to the absence of PO, the matter could not taken up, and the next date was given on
you make a prayer there.
9.
You make a prayer there for stay.
Your Honor, PO was absent.
So what? So what?
Therefore, during this pendency, Your Honor, this missed case has been passed. This NBW has
Naturally, that is different. This is different. Unless there is a stay, the magistrate will always issue non-bailable, bailable, whatever in the process. If you fail to pay, why you did not pay?
Your Honor, in the judgment, there are only 2 months is given. That's a very short period.
2 months not expired. When the order was passed? Let us see.
Judgment and order passed on 14/8/2025.
August,
Yes.
count it. September, October, November, December.
Yes.
Then what more you want?
Your Honor, I've already categorically I have stated I will
Statement, how, what that will do? How that will help you? Categorical statement, if you give 100%, 100 pages statement also, how it will help? Unless you pay.
Your Honor, I need some times to pay.
You make a prayer there. How do we grant? How do this court grant? Unless you challenge there, unless you make a prayer there in the appropriate forum.
Your Honor,
Have you made a prayer before the appellate court? Appeal is pending according to you.
yes,
Okay. Have you made prayer?
yes. For in a missed case, I have made a prayer to suspend the suspension of the
What happened there?
sentence.
What happened there?
Your Honor, the case was Your Honor, come to the page number 29 in this my petition.
Yes.
Case put up today, same is written by mediator, no amicable.
None of the parties are present.
Yes.
You were also not present.
Yes. And it was fixed on 24/11, Your Honor. But on 24/11,
Now, why
Suppose
you
the
did
matter
not-
was taken up-
why you remain absent on 17/10? And on 24/11, if you,
On 24/11, the PO was on leave, due to training.
where is the order?
24/11, Your Honor. There is I have, in my annexure 4, I have annexed to, as in the course list of the session court, district and session.
DNS, yes. See, you fail, and then going or approaching the higher court will never help you. It will never die. Ultimately, you have to pay back the money only.
Your Honor,
Even if you go to Supreme Court also, I don't know why this kind of advice is ill advice. You cannot avoid. It's a wastage of time, energy, and money.
Your Honor,
If there is an order for payment,
Your Honor, my humble submission is that the next day is on 9/1/2020.
next day, how, even if next day fix also,
Till,
third, fourth, fifth, okay, 100 time you have given, can you avoid payment?
no, Your Honor.
Then? This is, they are wasting. Yes, Miss Jenny, what can be done?
Yes, Your Lordship, if Your Lordship come to page number 30, which is the next impugn order, Your Lordship. Your Lordship will see the date given is on 4th, that is tomorrow, Your Lordship.
Yes, Your Honor.
Last paragraph, Your Lordship will see.
Yes, we appear there, make a paragraph,
Yes,
make a prayer.
yes.
See, did not make any application also, and then they did not pay also. So how they can avoid the procedure? How they can avoid the court? And see here, they are running from here to there. This is wastage of time, energy, and even the money also.
Your Honor, my humble submission
Under
is
the
that
circumstances, the good advice would be just to pay. And to show the benefit there, make some at least payment.
Absolutely.
Your Honor, my
For the
humble
time being, and
submission
make a request thereafter.
my humble
They
submission
can
is that
appear tomorrow before the court, seeking some explanation and recalling of these order, Your Lordship.
till next date, my right may be protected, Your Honor. Within that, I will manage to pay some amount, Your Honor.
Make this prayer before the trial court. Why you are approaching the high court? It's more expensive. Have you annexed the application file, appeal file before the session? What is the ground taken by you?
No, Your Honor, I have not annexed the appeal, but I have just placed the orders of the session court's criminal appeal orders.
How it will help you? There is no stay. And then you are blaming the court now.
No, Your Honor, I'm not. I'm just here to protect till.
And you
till-
wanted that nobody should should appear from the other side. Or you yourself did not appear on 24th and now blaming the court.
No, on,
See,
on 24, Your Honor, the PO was on leave due to training purpose.
on 17, who was on leave?
17 at the time, Your Honor, due to some problem, I could not appear on that day. On
Okay.
17, but thereafter the next date
24
was given on 24.
24, how do I know that you appeared and he did not appear? Where it says that on 24, he remained absent
Your Honor,
and you were present?
Your Honor, I have annexed the course list of 24, Your Honor.
In court list where it says that he was absent?
The already next date was, it is specifically not mentioned, but the next date was already given in session court. Your
See,
Honor.
You are putting the court also in awkward situation. Court knows everything. Only because you came, you have some approach seeking some relief doesn't mean that always you will gain sympathy of the court.
Your Honor, till next date,
Your
I will
conduct,
be
your conduct,
protected.
you say you have to show
In
the
between,
conduct.
I will manage and pay some amount.
Where did you say in the before the trial court and the appellate court? This same prayer, if you make before the trial court, they'll consider, you ask for some more days. These difficulties I am facing, and for the time being, I'm paying this much. And this much, some more time may be given to pay, to satisfy. And firstly, you have failed. It's not only the payment, you have been convicted. And that there also, you see, no serious. You think that if the judicial magistrate first class convict, there is a higher court, and the higher court, session court doesn't do anything, then there is a higher court, high court, and then there is a Supreme Court. Thereby, you will be spending more than what you are supposed to pay, what you have been directed to pay. Don't do that. Duty of the advocate is also to suggest some of the client for their benefit. Under the circumstances, there is no other way, but you have to pay only. And what is the other way? If he or she is facing a lot of difficulties for management and some more time required, then approach the proper and appropriate court with a prayer. But going higher, blaming the lower court or trial court, it will not help, never help. Court understand. Even if the court grants some relief also, but then permanently it will not remain.
I completely agree with your lordship. In fact, tomorrow they can approach the trial court stating that give me some period.
Yes.
So he can, if he's not able to
That
pay
can-
in a lump sum, at least
And NBWA and NCO can just make a small application, recall, I'm appearing, I'm ready. Finish. Why do you approach High Court? We have to think before preparing the petition. And then explore the possibility of settlement in the same court and then the higher with appropriate application. Higher, you have already filed appeal. What's the option there? Can you make an application? Praying, and then this they have issued. And can I make an application for a stay for the time being or giving some time? That is the only option under such cases. Mr.
Titaggo.
Hmm?
Titaggo.
T.
Taggo.
Tagu,
Yes.
Islamic Council for the petition. Also heard Mr. Gini, done an additional PP for the state. What is your prayer, by the way?
Your Honor, my prayer is stay oblique suspend the impunity till the next date of hearing. Your Honor.
Okay. Sarah, the applicant has been convicted for offense under section 138 of the NI Act and directed to pay a fine of rupees 2 lakhs and a check amount of rupees 10 lakhs, in total rupees 12 lakhs to the complainant, to the respondent stroke complainant, and in default to undergo simple imprisonment for a period of 2 months. Start. Para. Being aggrieved, the petitioner filed criminal appeal number 11 stroke 2025 before the session court UPR. Challenging the judgment and order dated 14/8/2025. Challenging the said judgment and order dated. Along with the missed case. Praying for suspension of sentence. A missed case under section 430 within bracket 1 of BNSS for suspension of sentence during pendency of appeal. Para. The appeal. No, not para. Continue. The appeal has been fixed. When the appeal is fixed, when the next date for appeal
9/1/2026.
is, the next date of the appeal is fixed on
1/2026.
9/2026. Para. During the pendency of the appeal by an order dated 28/10/2025, the Learned Judicial Magistrate, First Class, UPR. Issued non-bailable warrant of arrest against a applicant in miss case number 278 stroke 2025. Para. Now, miss 225, fixing next date for his, fixing next date on 4/12/2025 for his appearance stroke report on NBWA. Staff on para. By this application filed under section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023, the applicant is praying for suspension stroke stay of the impugned order dated 28/10/2025 in miss case number 278 stroke 2025 in connection with complaint case number 98 stroke 21 under section 138 stroke 142 of NI Act 1881 passed by the Learned Judicial Magistrate, First Class, UPR. Stop. Fair. The just a minute. From the above, it appears that the applicant failed to pay the amount to the complainant as directed on time, due to which the complainant stroke respondent number 2 filed miscellaneous application seeking, praying for arrest of the convict stroke applicant. However, the petitioner stroke convict filed an appeal before the court of before the sessions court against the judgment, and the judgment dated 14/8/2025. And although there is a prayer for stay of the execution of stay of the said judgment, execution of the said judgment, the same is still pending before the session court. Next date having fixed on 15. When did you say? 15?
No, 9/11,
Oh, 9/11.
9/1/2026.
Stop. Para. The under the circumstances, the applicant has also a remedy to make appropriate application before the trial court as well as before the appellate court. Staff, in view of the above, this in view of the above, this court proposed to dispose of this petition with a direction to the petitioner to approach the appropriate forum for with appropriate application for relief. Staff. However, since the appeal is hearing for the appeal is fixed on 9/12/2025, the till then there shall be no, so just a minute, and no okay, till then the petitioner is petitioner shall not be, sorry, the Hmm. But you failed. Arrested, not be arrested. Huh? This is on default only. The arrest direction is only on default. Okay. In execution of the NBWA. Okay. I'm protecting you till you approach the appellate court. Okay. So here also you make an appropriate application, do whatever, pay some amount, okay, and make a prayer for father. And in before the trial court also, because on 9th, probably your application will be considered. And then you can, apart from that, you can make appropriate application before the appellate court. Okay. If the appellate court is satisfied, then also stay. Okay. You approach there with the above this petition staying closed, disposed of.
Declare.
Much obliged.
Item number 4.
Yes. Item 4. Adjourn. This is item. For somebody sought for adjournment. Moreover, item 4 adjourn already. No. Item 5. Item 5. Which one was adjourned? 5. Okay, 4. Item 5. Four adjourn or 5? Not 4. But it was prayer on behalf of T. Topu.
I'm here. I was not taking adjournment. I was.
So that is why he clearly mentioned item 4.
Well,
The person who appeared, what is the, let's see, what dictation you have taken? Item 4, okay, you read 5 then, no. Out of station, yes, it was in item 4 only, write it on 4, in 4.
Item number 5.
Yes.
Appellant, Mr. B.R. Dunn, he informed me that he will come to BC. So I am here on the part of Bajaj Allianz Insurance Company. Respondent.
He is not present today. So,
But he informed me as per his information only I hurriedly come. And if he is absent, then
no, do you have any objection if this McAppeal is admitted?
McAppeal is steering tail case.
Has it been admitted already? Already admitted, then we'll list it for hearing.
Yes.
Record is also there.
Yes, yes.
Okay.
Hearing may be fixed, madam.
although Mr. B.R. Das, learned counsel for the appellant, remain absent, Mr. U. Deka, learned counsel, learned, you are for
I'm for respondent Bajaj Allianz.
respondent Bajaj Allianz. Okay, respondent insurance company. So is there any other?
Here, as
Private
three
respondent.
respondent, my lord, I am respondent number 1. Other respondents are not necessary.
They are also necessary parties?
I don't think so, my lord.
Okay,
Because-
then
Yes,
the trial Deka will present submits that although since the trial court record has been received, the matter can be listed, matter is ready for hearing. So in view of the above, let this matter be listed for hearing after 4 weeks. Okay,
Yes. oblige.
Item number 6,
yes.
My lord,
Yes, this is
On-
second appeal.
this is second appeal, my lord.
Hmm.
My lord, on this 13th of August 2025, the Honorable Additional District Judge of Basar, while deciding a Kaba appeal, passed the judgment based on the fact, on the question of law, that substantial question of law, that the prescribed procedure of CPC has not followed in the Kaba proceeding. So I have approached this honorable court with the
Where is that particular objection?
your lordship, my lord may come to page number 202. That is the impugned judgment, my lord. Page number
Yes.
202, and this is, my lord, paragraph 58 and 59, my lord.
Hmm.
My lord, here, the Honorable Court of Additional District Judge has said that this court is of view that without going much into the detail of the case, it is relevant to go through the law point. It is an admitted fact that even for trying the case under AFR, the procedure as prescribed in Civil Procedure Code 1908 is to be followed. And Section 16 of CPC 1908 provides that suits to be instituted where subject matter situate, subject to the pecuniary or other limitation prescribed by any law. Suits, clause D, for the determination of any other rights to or interest in the immovable property.
So when the Kaba was decided?
Kama was decided on 18th of August 2023.
Okay, 23.
Yes. So, my lord, here the section 18 of the Arunachal Pradesh Civil Code Act clearly specifies, my lord, that application of the code. Here, my lord, Arunachal Pradesh Civil Code Act, section 18 reads that the procedure prescribed in the code shall save in so far as is otherwise provided by this act, be the procedure followed in all civil code except the customary code.
Okay, where is the substantial question of law?
Yeah, so Arunachal Pradesh Civil Code
Let
Act.
us see once.
Yeah, so my substantial question of law is whether this Arunachal Pradesh Civil Code Act very clearly specifies that the prescribed procedure of CPC will not apply in
No,
customary
no,
code.
where is the substantial question of law?
In my plain petition,
Yes.
yes, my lord. My lord may come to page number 19, my lord.
Yes. Hmm.
The second appeal is being filed as it involves substantial question of law. Substantial questions of law. Whether the impugned judgment dated 13/8/2025 is perverse, illegal in setting aside and quashing the Kaba decision dated 18/8/2023, despite the said village authority of Nigam village having the territorial jurisdiction to try the case pertaining to the present subject matter between the appellant and the respondent. Number 2 is whether the learned additional district judge Basar was justified in setting aside and quash Kaba decision dated 18/8/23 of Nigam Village Authority, whereas the said Kaba decision was passed by maintaining the procedure given under Section 11 of the Assam Frontier Administration of Justice Regulation Amendment Act 2023, Act number 4 of 2023. Whether the learned additional district judge Basar was justified in law while deciding that the Nigam Village Authority has no territorial jurisdiction to entertain or hear the dispute between the parties by referring the provision under Section 16 of the Code of Civil Procedure 1908. Whether the learned additional district judge Basar was justified in holding that customary court shall be governed by Section 9 and Section 151 of the Code of Civil Procedure 1908, while Section 18 of the Arunachal Pradesh Civil Court Act 2021 provide that the procedure prescribed under the Code of Civil Procedure
Where the
1908
Learned
shall
Trial
not be.
Court- where the Learned Trial Court has said that Section 9
Yes, my
and
lord.
Section 151 of the Code of Civil Procedure will govern
Yes, my lord. Here,
the customary court will be governed.
yes, my lord.
The customary court will be governed by this Section 9 and
Yes,
151.
here it is.
The trial.
My lord,
court
it is
says that yes.
Page number 200, my lord.
Hmm.
Page number 200 is that, my lord, is copy of the judgment,
Yes.
impugned judgment.
Hmm.
From paragraph 50, 51, 52, 53, and 54 are the explanation of law. Explanation of law regarding CPC, my lord. The learned additional district judge Basar has referred the provision of CPC while deciding the issues. My lord, here's at para 50 of the judgment, my lord. It was observed that provision of Section 15, Clause 3 of the Arunachal Pradesh Civil Court Act 2021, Section 9 and 15 of Civil Court Procedure 1900 will, being relevant, are quoted herein below as.
So, according to you, Nigam Village
Yes.
has a jurisdiction.
Yes, lordship. My lord, here both the parties are resident of Nigam Village, my lord.
Okay.
Yes.
So
And
the
that
Learned
is-
Trial Court says that Nigam Village doesn't have a jurisdiction.
Territorial jurisdiction, my lord, because
Doesn't have a
the
territorial
land is, the location of the land is disputed. Now, while deciding the question that whether the Bridge Authority of Nigam Village has territorial jurisdiction or not, the learned additional district judge has decided that the territorial jurisdiction of the village authority shall be decided under Section 16 of CPC, my lord. So now the question is, my lord, when the Section 18 of Arunachal Pradesh Civil Court Act clearly specifies that the procedure prescribed under this code will be not applicable to customary court, my lord, then the determination of place of suing is also a prescribed procedure of civil CPC, my lord. And nowhere in the Assam Frontier Administration of Justice Regulation 1945, my lord, up to that Amendment 4 of 2023, there is no reference, there is no mention that the CPC will apply in the AFR, my lord. So here, my
When
lord,
did you say the Kaba decided?
my lord, yes, my lord,
Kaba decided on which date?
on 18th of August 2023, my lord.
What was the decision?
Decision was that, my lord, this the present respondent did not turn up for the 3 occasions, and while maintaining the provision given under AFR, my lord, the keeping a gaping of 30 days on each Kaba date, this decision was passed, my lord.
What was the decision?
Decision was passed that this land, disputed land, belonged to me, my lord, the present appellant, my lord. So the respondent,
So the land was under his possession or
it is under my possession, my lord.
let us see the Kaba decision once.
Yes, my lord. My lord, may please come to page number 66, my lord. 66 is the English translated copy of the cover labels, village level cover decision, my lord.
Who is this Idak Basa?
He is the appellant, my lord. He is the present appellant.
Okay, present appellant.
Yes, my lord.
How many respondents? One.
Only one respondent.
Yes, we can issue notice.
Yes, my lord.
Heard, Mr.
Kevam Tasso, my lord. Ketas.
Ketaso, Land Council for the appellant. Para. This appeal has been filed under section 100 of the Code of Civil Procedure, read with section 151 of the, no, and read with section 151 of the CPC, against assailing the impugned judgment and order dated 13/8/2025, passed by the District and Sessions Judge holding the additional district judge Basar, holding the charge of additional district judge Basar in civil appeal number 05/2023. So she reversed the judgment,
Yes, my lord, that is my prayer.
reversed the judgment and decision passed by. Where is the Keba dated? Keba, what was the page number? Keba decision?
Page number is 54 is the original Kaba decision, and my lord,
Keba decision dated?
18/8/2023.
Decision dated 18/8. Whereby the learned additional session judge holding the charge of the additional session judge has reversed the judgment and decision, reversed the Keba translation of the village level reverse the judgment and decision of the customary court dated. Which customary court?
Nigam
Customary
village, my lord.
of Nigam village
Yes.
dated 18/8/2023. Staff, para. Issue notice. Call for the trial court record. The petitioner, the appellant shall take steps upon the respondent by a speed post as well as by usual process within a week from today. List this matter after 4 weeks. Okay.
Deeply up.
Item number 7.
My lord, I am personally agree with the concurrent findings of the trial court as well as first appellate court. Thereby, my lord, non-granting of priesthood interest. Priesthood interest has not been granted in a money shoot. Only a interest for the penalty and a post decree that has been granted.
You did not make any prayer.
It is made.
Where?
It was pleaded in
Have you
the,
annexed?
yes. In the
Yes.
plaints, my lord.
Hmm?
In the plaint of the this
Yes.
it was categorically pleaded that the interest, priesthood interest was claimed and the suit was filed. But the first appellate courts has misconstrued that I have never pleaded for the pre-interest.
Okay. Let us see your plaint.
Then he said 15, page number 15.
Yes.
This is the course title. My lord, will find my prayer at page number
50 page.
no, my lord, at 26.
Hmm.
26 is the prayer portion.
Hmm.
So, my lord, basically the actual amount was of rupees 20 lakhs was the principal amount. And it was expressly agreed between the parties that 5% per month shall be charged. So altogether,
Where is your prayer
at page number
for
2,
pre-litigation fruit? Page 26.
page 25, it starts from page number 25,
Hmm.
clause 1, a decree order directing the respondents to jointly inasmuch as to severally pay the total debt amounting to rupees 1,14,49,084 rupees. So it was inclusive of the priesthood interest. thereafter, well, we'll see, along with accrued interest as discretionary imposed by this honorable court from the date of institution of this suit.
Hmm.
So this along, it comes later, but the amount of this 1 crore, it was accumulated along with the interest, which was imposed on the principal amount.
Now, what is the calculated amount then?
It was,
Whether the calculated amount include this 114?
yes.
Hmm?
This principal was only of 20 lakhs. So it came up.
You have
one-
not mentioned clarification specifically.
Oh.
It appears that the amount, total amount,
Yes,
the loan amount is 114.
114. But in my paragraphs, categorically mentioned that actual amount was of 20 lakhs
Where?
at page number 19. Para 3.
Hmm.
The factual facts of the case in a nutshell is that in the year 2019, the respondent number 1 has approached the plaintiff and requested for lending a sum of money amounting to rupees 20 lakhs in a loan basis so that she can invest in her ongoing business. According to the plaintiff, while having good acquaintance in as much as upon his good faith, has given a sum of rupees 20 lakhs in the form of friendly loan basis, and in pursuance, the loan agreement on dated 30/12/2019 was executed, wherein it was agreed that the payable interest of 5% per month over the principal amount, which rupees 1 lakh shall be payable.
Where
to
do we
the-
find that this 20 lakhs,
Yes,
including the interest of 20 lakhs comes to around 114?
it is because, my lord, there was an express contract, which is at page number 29. It was agreed in between the parties that 5% per month shall be chargeable.
Hmm?
So thereafter,
No, where from? Or where do we find the calculation of the
yes,
amount? The initial loan amount is only 20 lakhs.
Yes, it was taken in the year 2019, and the suit was filed in the year 2022. So for these 3 years, the amount
What was the suit value? Just a minute.
suit value was it was valued at rupees 1 crore, 14 lakhs. So thereafter, my lord, what happened is the pleadings of the plaintiff was categorically admitted by the respondents. However,
You have
the-
probably nowhere stated that this 114 is inclusive of the interest of this 20 lakhs pre-litigation.
my lord, when I have counted and when I've inserted that amount, there is along with the
Where have you mentioned that this is inclusive of the interest,
my lord, in my
pre-litigation interest?
at page number 22, para 8 as well. That thereafter accordingly, even after the service of legal notice, the respondents have not made any endeavor to comply with the demands of repayment of the payable amount. Therefore, the plaintiff opted to seek legal course of action, and in accordance, for the sake of brevity and clarity, the plaintiff has prepared a calculation sheet on 15/12/2022 while computing the entire payable amount, which is inclusive of principal borrowed amount, interest charged therein, and the penalty for default and finality. The total payable amount is computed at rupees 1 crore 14 lakhs 49,084 rupees for 36 months, vis-a-vis from the January 2020 till the month of December 2022.
Okay, where is the decree?
Decree is of there is 2 decree.
Hmm?
This first degree is at page number 61. This was passed by London Civil Judge Senior Division UPA as a trial court.
Okay, so how much amount was directed to you?
My lord, will find this operative person at page number 65.
Suit for realization of on court.
Page number
Okay,
65. 65.
Okay,
This para 7, 8, and 9. May I read about?
yes.
As regards interest, the plaintiff relies on the stipulation of interest at 5% per month, which is an additional 5% penalty over the monthly interest in case of delay. Such stipulation is exorbitant and in substance penal. In view of the settled law that penal interest is impermissible and that unconscionable rates can be scaled down, these courts decline to enforce the contractual penal interest clause. The appropriate course is to grant reasonable penalty and future interest under section 34 CPC on the principal sum decreed. Para 8, further priesthood interest is also claimed. However, in the absence of a clear and admitted basis, this court is not persuaded to award priesthood interest. Accordingly, the claim for priesthood interest is rejected. So, Director, at page number 66, my lord.
Page?
This paragraph 11 at page number 66. Thus, in view of the circumstances and the discussions above, the suit stands decreed under Order 12, Rule 6 CPC for a sum of rupees 20 lakhs in favor of the plaintiff and against both the defendants jointly and severally with cost of rupees 10,000 only.
Okay, you calculated by yourself and did not mention anywhere that you are claiming priesthood interest also. It appears.
My lord, will see at para 8 at page number 65. Trial court has also categorically held that priesthood interest was claimed at para 8.
In the absence of clear and admitted basis.
My lord, what happened is in this case, this suit was never went into trial. When the respondent they have filed their WS, they have categorically admitted the principal amount. Therefore, an application was filed by the appellant as plaintiff under Order 12, Rule 6 for passing of judgment on admission.
What is the substantial question of law involved here then?
Granting of priesthood interest. It doesn't come within the ambit of Section 34 of the CPC. Section 3 of the Interest Act, it says it is grantable. That part has not been accessed by the London trial court. And even
this probably the London trial court has appreciated and then come into conclusion on the basis of the fact only. How the question of substantial question of law involves here? What substantial question of law involves here?
Follow this granting of priesthood interest, it does not fall within the ambit of Section 34, which deals with the interest of Section 34 of the CPC. Whereas Interest Act, Section 3 says, granting of priesthood interest, it is accessible and it has to be accessed on a ground of equitable jurisdictions. Because, my lord, for 3 years, these respondents have illegally retained my money.
Now, see, although here it mentioned priesthood interest is claimed in absence of clear and admitted basis, this court is not persuaded to award priesthood interest. What admitted basis it says?
Admitted, my lord, the part of principal was admitted, but the respondent has denied the rate of interest. So that was correct on the part of London trial.
Let us see your substantial question of law. What are those? If you have formulate it.
It starts from page number 11.
Yes.
whether London Trust Appellate Court misinterpreted section 34 of the Code of Civil Procedure 1908 by holding the interest rate cannot exceed 6% per annum, ignoring the fact that transaction between the
As per
parties-
CPC, it's not more than 6%.
Yes, but it can exceed if the contract is for commercial transaction. And in this case,
Yours, according to you, is a commercial
yes,
transaction.
yes. Because it was taken for some contract work.
But yours is not an institution.
Well, this section 34 provides which defines what is commercial. It has been taken for trade, commerce, or for a business,
Even from the private.
even from the private.
Where do I find?
There is not so, but for business, and there is no dispute that this was never taken for any kind of business. It was taken for the business purpose.
So according to you, priesthood interest is not within the discretion.
Malum. What I'm humbly submitting is the interest which was charged in between the parties, it was against the public policy. Because 5% interest per month, it was and it is exorbitant and excessive. However, the landed court below could have granted the priesthood litigation in accordance with the interest rate being charged by the Nationalized Bank of India.
Probably, according to prima facie, it appears it involves with the fact. Anyway, what we can do is at the moment we can issue notice. Prima facie, it appears it involves with the fact only. Okay. Hard Mr. G. Dibba. Sorry, Mr.
Jiruba.
G. Dibba. Land Council for the appellant. Para. This is an appeal filed under section 100. Read with order 42, rule 1 of the Code of Civil Procedure 1908. Selling. The impugned judgment and order dated 14/10/2025 passed by the Lanet District and Sessions Judge UPA in money appeal number 01/2025, whereby the first appellate court dismissed the appeal filed against the impugned judgment and order decree dated 29/08/2025 passed by the Lanet Civil Judge Senior Division UPA in money suit number 105/2022. Stop. Issue notice. Call for the record. The appellant
May I please? Well,
shall take steps upon the respondents by a speed post as well as by usual process within a week from today, starting. List this matter after 4 weeks.
May I? All of this substantial question of law, it has to be formulated more before issuing of the.
So at the time of admission, will admit it
Yeah, yeah. Good.
on the substantial question after appearance of the respondent. Okay.
But Malud, this name of the appellant has been repeated as Lipi, but he is Lip. That make
You have to correct it.
Yes. In petition, it is correct,
Hmm?
but in the petition, it is correct.
In the
Petition, it has been rightly mentioned, but in the course list,
in the cause list. Okay. The learned counsel for the appellant submits that the name of the appellant
Yes.
is wrongly mentioned as
Lipi.
Lipi at the
Yes.
instead of
Lipa.
LIPE.
PE.
The registry shall correct the spelling of the appellant and appellant in the course list. Okay.
W.
Item number 8.
My lord, before the case is taken up, my lord, I have got the file, but I just forgot to bring some books because I have raised the question of maintainability, and that will be books will be required. So may I pray that this may be taken up tomorrow, my lord. 1945 regulation and AP Civil Code and other.
Otherwise,
See-
I think this can be listed for hearing. I think it will take
Yes.
little longer time, it appears, what I found. Although you say that it's easier, it seems, of course, a very small question from your point of view.
My lord,
But
only the question maintainability.
Yes,
Can just taken up tomorrow, my lord, because
tomorrow.
yes, because the factual part is apart.
Hmm.
But then maintainability, because they have categorically made false statement.
Okay.
I'll just show you, Your Lordship,
Hmm.
how they have made false statement and what are the outcome of those.
So that is why I thought that it might require little longer hearing
We'll take
because we will
just
be
half
going
an hour.
to the huh?
Just will take half an hour. We'll see tomorrow. my lord. Because there is no point keeping up the method this thing, because there is an interim order also, and in the meantime, after that government decision, we have made substantial development in the area, but then we are not being able
Tomorrow
to.
probably.
And then
Tomorrow is a Wednesday. Wednesday probably in the division matter, probably a little bit of hearing may also take. So we will be having a less time tomorrow.
Day after tomorrow.
Okay. Okay. As prayed for by Lana Council for the parties, let this matter be listed. Day after tomorrow would be on
4th, Lordship.
on 4.
Oh.
Hmm?
Yes,
On. Okay.
4th or 5th, my lord. On 5th, there will not be much cases. Otherwise,
Okay. No, 5th.
5th is Friday.
5th, no, on 4th.
On-
Okay, 4th.
All right. I'll just argue on the question of maintainability.
Okay.
Item number 9.
Yes.
It's not hearing before the lordship was convicted under section 326 by the learned judicial magistrate first class.
Yeah.
And thereafter we have filed an appeal. The appeal was also rejected, dismissed. There, meaning by the sentence was affirmed. He was convicted for 2 years with a fine of rupees 10,000.
Whether he is inside or
No, he is in jail.
in jail.
He-
How long he has been?
Now it's 3 months.
3 months.
Yes, from the date of judgment now. Can it taken up for final disposal? It will not take much time. Only 5 with evidence are here, witnesses.
Okay. But then what about the respondent?
Respondents, learned PP is there. The respondent number 2 is no more informant. He was expired.
Who is respondent number 2?
The respondent number 2 is PW2. This
Why
development
why witnesses have been pleaded? Is a informant.
informant, my lord.
Okay.
Now we came to know that
He is no more.
he is no more. 2-3 years before he died.
Okay, the respondent number 2 is the informant is the victim.
He is the victim, my lord. He was the victim.
He was the victim.
Yes.
Okay, you have pleaded only the,
No, you want one more? Here is the next. Yes.
have you received the record?
A report was there, my lord.
Okay.
Receipt.
No, then, whether
Lordship can appoint an amicus in that case since
amicus will have to be
Ma'am.
appointed, and then whether the paper book is necessary.
it's necessary because I was in fact I
Hello,
would
it's
made
only
make
for
a
two-
prayer because
Huh.
since this is also challenging the order of the appeal, your lordship. They had approached the sessions court in appeal, your lordship, and
Okay.
sessions court had upheld the sentence in the trial.
Now, in that case, probably because not only the sessions court,
Yes.
but
my
then
lord.
also
In
the
that-
trial court also, I think yes,
Yes, my lord.
paper book would be necessary.
In that case, my lord, my IA may be considered, my lord. No, it will take hearing, my lord.
See,
Because, my
your
lord, can-
appellate court has affirmed your
Well,
conviction.
yes, my lord. That's
Hmm.
why I'm before. My lord, whether only one single question of law is here determined,
Okay,
required to be determined.
what is that?
Whether, my lord, section 322 grievous hurt, where it is defined, whether it is applicable in the present case. Assuming there is an injury, the victim was sustained injury, whether
It's a grievous.
whether grievous injury was applicable in the present case or not. Ma'am. There is nothing in the medical report. The
No,
medical,
you said that as per the medical report, it is grievous injury.
as per the medical report, initial medical report was taken to CC.
Huh.
It was doctor said, just kindly see exhibit 3, my lord.
It's not
Simply it is said, my lord, injury.
It is not annexed with the petition.
No, it is there the report, my lord. Page 7.
Anyway,
It is
according
said,
to,
my lord, cut injury 12 inch, my lord, whether it is possible, what in the head, my lord. If it is an animal head, then 12 inch will be possible. 12 inch side scalp over the ear.
you must have cross-examined,
Yes.
you must have cross-examined the doctor.
Cross-examined, my lord.
What the doctor says
Yes.
then, when you ask that it is not
It is
possible,
PW4, man.
what is it? Just simply,
Yes.
what was the doctor's reply when you ask, it is not possible, or is it possible in human being?
My lord, may I read page 31
Yes.
of the,
Just read.
may I read more? On 2012, I was posted at Mahadevpur
See the
CHD
relevant.
medical officer. I have been summoned by the court in connection with with the injury sustained by Sri Digonta Max on 10/5/2012 at around.
See the,
17:50.
only read the relevant
Yes,
injury
my
part.
lord. Relevant is, my lord, what he said. To my view, after examining the injured portion on the head, the nature of injury sustained by the victim was grievous caused by sharp weapon.
Hmm.
Exhibit 3 is my report of the
Hmm.
injured person is so and so. Then what he also said, man, the length of cut portion was about 10 to 12 inches.
Hmm.
Whether it is possible, my lord.
Length,
And length
So
and white
from
of injured
skull
portion not
over
very
ear.
clear. White of the injured portion not very clear. But there was a gap. Only one cut, whether there could be a gap, my lord.
if,
My lord,
if,
and
if the space or the way it has been hit is not, no, is a smooth one, may not be possible, but if it is not a smooth one line, then it is possible because you have a up and down.
no, my lord, it is, they said only one cut injury of 10 to 12 inches. My lord, if it is a head of 12 to 10 inches, can it be possible, my lord? Our.
I have no idea.
Human
But
health-
then you are, what,
My lord,
what,
my
the-
lord,
what was the
I-
reply of the doctor?
My lord, in a normal sense, my lord.
No, what is the reply of doctor when you ask that it is not possible? Did you ask?
I have not mentioned the, my lord, in the cross, my lord.
Hmm.
I had not mentioned that injured person are brought to me by the police. It is not mentioned in my injury report regarding how I had administered or treated the injured person, though I conducted all the necessary work, treatment, including first aid, stitching of the injured person, and other necessary medicine. It is normally not mentioned in the medical report or injury report about what and how injury was treated or administered in details. My lord, he also said I have been admitted in a private hospital in
No,
Dibrugarh.
where, no, there is no answer to your
No,
question.
no, there is no document exhibited by the prosecution. Only, my lord,
What more document other than the medical report?
my lord,
On the basis of medical report, the doctor has stated,
my lord,
and then you did not ask that
Yes,
it
my
is
lord.
not possible, is it possible, is it not possible? You did not ask
suppose
that.
there is an injury, my lord,
Hmm.
whether it is the ingredients of article, section 326 is applicable. To my understanding in law, my lord, is not applicable. It may be hardly a case of my lord 324. It's not
Oh.
326.
Hmm?
Assuming, my lord, I admitted, my lord, there
See,
is a
what is the minimum punishment for 326? Minimum, is there any prescribed minimum?
minimum is, my lord,
23, 26, it will go, I think, how much, 10 years? It can
he
go,
was convicted for 2 years.
no, so what is the punishment for 326?
326, my lord,
3 years.
shall be punished with imprisonment for
It is more, I think,
voluntary causing hurt by instrument shooting.
326 is,
Punished with imprisonment for life with imprisonment.
324 is
either
3 years
that-
and 326 is 10 years.
you see,
Life.
that is why I'm, so, but then he was convicted on a 326 only for 2 years.
2 years, my lord.
Hmm. We will increase then.
No, lordship, that section itself is not applicable, my lord. So my humble prayer, my lord, till let the matter may be adjudicated, my lord, hearing may be taken place. In the meantime, my lord, I may be allowed to go on bail for a limited period of time, my lord.
If I may suggest, your lordship,
Therefore, my lord, I may be considered, my lord, at this stage, my lord. Let the matter may be fixed for hearing.
Life for 10 years. So that is why I was surprised. Why only 2 years in 326?
I may just suggest, your lordship,
Yes,
since the record is also available, your
Hmm.
lordship, and as has.
can we fix for
been-
hearing
Yes,
immediately?
yes, because they have the medical report and they are arguing on medical report to get a stay, your lordship.
Hmm.
That has never been annexed in the
No,
petition.
my lord, it is on
Sir,
record, my
That's
lord.
what I'm trying
It is on
to,
record.
I'm trying to.
Okay.
This is an executed document. How can I make it record?
Why cannot it be
It is a-
annexed along with
Okay,
the
then-
petition?
then-
Because
so
this petition
then,
is
What
also,
we'll do,
That's why report was called for before considering my
okay,
IAS.
the
so
paper book may be.
let the paper book be prepared,
Yes.
and then since you said that, and then we, in the meantime, we'll appear, we'll appoint one amicus, okay?
Immediately after the,
That may be
immediately
true, my-
after the
that is-
vacation,
I don't have any objection to that, my lord. My only prayer, my lord, humble prayer before Lord.
No, there is a
Till
prima
then, I may
facie
be
one
allowed to
part
go on bail, my lord. The sentence may be suspended,
Yeah.
my lord.
problem.
And there is one judgment of our High Court also, my lord.
Mr. S.K. Deori, Learned Counsel for the petitioner. Also had
You are-
Ms. P. Ginny, learned. Ginny for the additional PP, a public prosecutor for the state staff. The tribal record has been received, staff. Mr.
No, last occasion it was on the,
Deori, Learned
that
Counsel
this
for the
matter may be
petitioner,
hard, that's why
informed
it
this
is
court
for
that
admission today.
brought to the notice of this court that the respondent. Private respondent number 2, victim. Has it come on record?
No,
If victim is no more?
no, Your Lordship, it's a verbal submission made by the.
Okay.
No, he's no more. It is a fact, my lord. And he also doesn't want to pursue this
Okay.
matter. Any sentencing, my
the-
lord.
Just a minute, the office note. So, office note, since 7/11/2025, 6/7/11, 15/11, 24/11. In a month, it has been listed for,
No, last week it was listed, my lord, and it was listed for orders. And lawsuit was on the view that this whole matter may be heard. That's why today it was listed. On 27, the
Hmm.
matter was listed.
On, Your Lordship will see on 17, the matter could not be reached because of the paucity of the time, Your Lordship.
Ah, that-
Mhm.
On 26, the TCR was received by this honorable court and the matter was, it was,
see, in a month, it has been
Yes, it
listed
has
for
No,
three-
my lord,
five,
it was
6 times,
listed
6 times.
6 times.
Yes.
Every time I'm pursuing for that, my lord.
See, and then within this month only, this is verbal information that the respondent is no more.
yes.
How-
My lord,
it- mm,
I'm honestly saying to the.
that is-
For the bar, my lord. it
Yes,
is
of
honest-
course.
the information
Yes, of
is
course,
more.
no reason to disbelieve. But then this has been listed 6 times in a month. And only this time, only. Okay, when he expired according to your information?
My lord, 2 years before.
Clear, before
Yes.
passing,
After, my lord, passing the judgment.
when the judgment was passed, Passing the judgment,
2022.
22, and then
Yeah.
appellate court passed
Episode was in
F1?
2025.
25.
Yes,
So by then he was not,
yes.
okay, it didn't, it hasn't come on record before the
No,
appellate
it
court.
has not come on record before that.
Okay,
Obviously, it will not come.
the
It
office
was by us.
note reflect that the service upon the respondent number 2 is still awaited. However, at this stage, Mr. Deori submitted a bar that he has confirmed information that the respondent has passed away some 2 years back. In view of the above, come.
In fact, under the High Court rules, my lord, so such type of case, my lord, paper book is not required. To my understanding, my lord. High Court rules.
It's easier.
It is more than
It's-
7 years. Then
It's easier for all parties.
it is,
Mm.
of course, my lord, it is convenient for all,
Because
but
here,
only 5.
here in the outlying bench, the judges are being posted for a week or 2. So second time, it might not come also.
So in
For
fact,
first
it
time,
is-
and
For the
it's-
end of
In
justice, my
fact,
my
it is
client-
also expected from the other side that all
Hmm.
the documents be annexed with
Yes,
the.
yes, mm.
If that
Yes,
was,
every-
if that was the
So,
case, paper. book-
Some document from here, some documents from there, it's very difficult sometimes. When you, especially when you see it for first time before the court, and then even if the case is kept as a CAB also, it's very difficult to,
And also if the information,
unless you,
main document is
Hmm.
the
And also-
injury.
unless you dictate it in the court.
and also see if the information that the respondent had expired was brought before this court or at the very first date, in that case, even the process of notice would not have been necessary.
Hmm. This, from which district?
My lord, it is from Namsai.
Or Namsai? Then,
Namsai, my lord, already record team, my lord.
Mr. Minke, Bose from the panel advocate. He is appointed as amicus curiae to represent the private respondent. Stop, huh? Since the trial court report has also been received, the registry is directed to prepare a paper book. And as the appellant shows some urgency, the preparation of the paper book would be expedited so as to complete within 30 days from today. Okay?
30 days. We'll pay the cost, my lord. We are ready to pay the cost for preparing the
Prepare paperwork at the cost of the appellant.
Let it be on 9th
Mm.
of December.
Expedited, preferably within 3 weeks. Okay?
Let it be, my lord.
Paperwork, see, we have.
Yes, my lord, it's
Mm.
today, it's 12. My lord, let it be on 16, my lord, hearing day.
16 would be,
16th of December.
after how many days that would be?
This after a
At
week.
least it after 3 weeks. Okay?
My lord, I pray for a date, my lord.
Okay,
16, my lord.
16. 16 would be difficult, I think.
Then
Paperwork, it takes time.
My lord,
Takes
18,
time.
my lord.
Lordship,
Because-
Because
immediately after
paperwork is-
vacation.
It will be how many paperwork, how many copies?
My lord,
Three
last
copies,
occasion,
3
my-
copies,
including the court, 4 copies.
4 copies. It will take time.
Lordship,
Within
immediately
3
after the
weeks,
vacation.
My
At least this
otherwise-
matter on 22. Okay?
22 is too far, my lord. Anyway, my lord, because my
Your
client
Lordship,
may
in that case on 23rd, because 23rd is a hearing day, Your Lordship.
Okay, 23rd. Okay.
DPO.
Because last occasion, my lord, this PP has not did not make any submission that paper book is required. For me also not paper book is required, my lord. Because under the High Court rules, if the offense is more than 7 years, then only.
Then you will not use paperwork. We only will use paperwork.
Of course, my lord, because my client is suffering, my lord. For the
Yes.
end of justice, my lord,
And
kindly.
that is why, see, in such cases, I've seen,
Yes,
the
my
judgment.
lord.
There's a material against you.
There is a
And then
material
you have been convicted only for 2 years. Although,
assuming, my lord, there is a substance against me, injury is there, cut mark is there. Whether it is come under section 320,
according to you, then it comes
it will
under,
not come under section 326, it will come under section 324.
okay,
At
what is the
best.
punishment? What is the punishment there?
Punishment will be
Three years.
applicable more
3
less than, my lord. 6 months also High Court judgments are there.
Hmm?
6 months.
How?
Our High Court judgment are there.
24?
Yes, my lord. It's reduced to 3 months or 6.
No, reduce, that is, I understand. Here also life reduced to 2 years.
Yes.
But
One case, my lord, it was convicted for life, but the Honorable Supreme Court said, it was reduced to 5 years.
let it be there for some time,
That's
some more
why,
days,
my lord,
so that it
my
reduce.
client is-
It will be easier for the High Court also to
Of
reduce
course, my
it.
lord, this is true. I am not, it's
Hmm.
with your lordship, but
Okay. That will be your advantage only. I'm telling you.
no, my lord, it is injustice caused to my client, my lord.
He has been heard in
Okay.
the.
Injustice. The
Yes.
person who got injury and he is no more now. Okay.
No, no, my lord, not for,
DPO
it's not,
Maybe.
he is no more, not for me, my lord. It's no more for.
We
some
don't
other-
know, but the person suffer. And so many, you see, side effects, mentally, physically, whatnot.
My lord, to that extent, whether there is a medical report, there is no exhibition,
There is
there
a
is no
medical
medical
report.
document.
Anyway,
Seven
okay, next.
except one.
Yes, we'll take up.
Right, my lord.
Item number 11,
Yes, your lordship. Lordship, on last occasion, I have taken the step against respondent number 2 and 3.
Okay, what happened then?
And on last occasion, your Lordship had called for the TCR record as well.
Hmm,
And
have we received?
your Lordship?
Have we received the PCR?
No, no, your Lordship.
Not, okay. Scan copy not yet come.
No, not sure.
Okay. We have taken steps, so.
If service is not completed, then your Lordship may allow me to take a first step.
You want to take fresh steps?
Yes, Lordship.
Okay. The office note dated 29/11/2025 reflect that the trial court record and the service report upon the respondent number 2 and 3 are still awaited. Stop. In view of the above, Mr.
T. Pumbo,
Nane Council for the petitioner praised for allowing him to take fresh steps upon the respondent number, the private respondent number 2 and 3.
and your Lordship may kindly fix this matter on 19th of this month.
Steps upon the respondent number 2 and 3 by speed post as well as by user process within 3 days from today. Stop. The registry shall also issue reminder for the trial court record. Stop. Para. List this matter after receipt of the record. Okay?
Yes.
Hmm.
On 19th of this month.
19.
If yes,
It may be difficult to fix it. 19 because the record is to be received and then the steps you have taken, you are yet to take.
because your Lordship 19 from today is about 16 days, your Lordship. More than
16 days.
Yes. From
16
today,
days,
if we count from today,
60 days or
16, 1, 6.
16 days.
Yeah, I think that much time will be enough for the reports to come, your Lordship. And for me to take a step.
Okay, as prayed for by the Lane Council for the petitioner, let this matter be listed again on
19.
19 December. Okay.
I live with.
Item number 12,
Your Lordship, in item number 12, we are yet to receive the CD, Your Lordship.
Is it?
If Your Lordship just give us some few days
You are under
on 8.
the interim you are protected.
Yes, yes, madam.
Okay. Mr. T. Lane Council for the petitioner is present. Miss Jenny, Lane additional PT, raised for some is that she is yet to receive the, it's a case diary.
In case I Your Lordship. On 11th.
Okay. Some more time, press for some more time to produce the case diary, the prayer aloud. List this matter
On 11, my lord.
on 11th.
Yes, Your Lordship.
Okay, start. Okay,
But it may be continuing.
the interim order passed earlier shall continue till then. Okay.
Oh, please.
Item number 13,
Your lordship, I have prayed for the adjournment.
Okay, yes. You were to file an application, interlocutory application for striking of the name of respondent number 2. You have not yet filed.
We have not,
Okay, you file, okay? Mr.
your lordship, may I? The whole petition is all about the respondent number 2. He is the co-accused. If we strike out, then it will be a problem. Let the
Okay.
leading counsel can. Our prayer is that
It was, you made a prayer to file interlocutory application for striking of the name of the respondent number 2. Now you don't want.
Your lordship, the prayer on this petition is all about the order, quash the order dated 18/2/2025, in which the respondent number 2 has been
Okay, who
discharged.
is, you are for?
I'm for respondent number 3.
3.
Yes.
Then you have to take steps upon the respondent number 2, again, over and again.
Okay, we will.
I think in the last occasion it was submitted. Okay, you are appearing for the first time?
Yes, Your Honor.
Okay. You are Mr.
T. Tolo, on behalf of Aringo.
T.
Tolo,
Your
on
name
behalf
is
of
there.
Aringo. Your
You-
lordship, on behalf of Aringo.
Your name is in the cause list.
Not yet.
You have not yet not filed wakalat nama.
Yes, on behalf of Aringo.
Okay, Mr. T.
Tolo, TOL.
Todo Lani Council appear on behalf of Mr. Minane is present on behalf of Mr. R. Ingo, Lani Council for the petitioner. And you are for?
Respondent number 3. But in the earlier occasion,
Respondent number 2.
Yeah.
You are very wise. We were talking about respondent number 2 and you kept silence. This is too wise. Huh?
your lordship.
No,
in the
he
last
want-
occasion-
Huh?
in the last occasion.
Yes.
the Petitioner
Huh?
had submitted before this one report. that
Huh? You are not necessary party. He was eliminating you. And you are,
But now if the petitioner is saying that he is necessary.
Let the leading counsel maybe appear.
okay, what he will do?
I think they may convince that he is related.
No, what is this case about? Just a minute. Huh? Okay, anyway, if you don't want to file, then since you are for respondent number 2, you are for respondent number 3. Okay. Present, huh? And Miss El Hage, learned additional PP for the state. You, Mr.
proceed
Posi,
for respondent number.
learned counsel for respondent number 2. Miss K. Yorak,
Yes, Your Honor.
learned counsel appear on behalf of the respondent number 3. are present. Have you filed wakalatnama?
Yes, Your Honor.
Hmm?
Yes, we have filed wakalatnama.
Okay, your name has been reflected here?
Yes, Your Honor.
Okay, then it's fine. Okay, so now you are a necessary party. You want to file anything? Any affidavit, anything, or the court has,
I'll file reply.
and you?
Your Lordship, some time may be given since we are appearing for the first time.
The land council appearing on behalf of the private respondent number 2 and 3 raised for some time to go through the petition and to file response if necessary. File code record received.
Yes, Lordship, it's already received.
Let's pray for list this matter. When do you want this matter to be listed?
Your Lordship, there is an interim.
Okay, interim. But when do you want? After?
3 weeks.
Let's pray for list this matter after 3 weeks. The interim, what interim was there?
Don't know. Did not check.
Till the next date, further proceeding of POXO. This is a POXO case. The interim order passed earlier shall continue till the next date of listing. Okay.
Much obliged.
Item number 14.
Yes.
My lord, in respect of item number 14, I'm appearing on behalf of Sarme.
Help for me. Okay.
In this matter, a certain report has not been completed.
Still awaited. Okay. Mr.
T. Roland.
Lana Council appear on behalf of Mr. L. Parme, Lana Council for the petitioner. Stuff. Ms. L. Hage, Lana Council. Lana additional PP is present on behalf of the state respondent. Staff. Service upon the respondent number 2 to 8 is still awaited. In view of the above, let this matter be listed after 2 weeks.
Okay, my lord. My lord, one thing, I may be allowed to serve a service today. Respondent, my lord.
Respondent.
Yes, my lord. Allowed.
Okay. Then, in view of the office note dated 29/11/2025, the Land Council for the petitioner prays for allowing him to serve to take steps upon the respondent number 2 to 8 through the concern office, concern or
Officer in charge.
officer in charge police station through to be routed through the office of the PP.
No, Lordship,
No,
to
no.
registry only.
Okay, so we routed through the registry. The prayer is allowed. The steps as prayed for be taken within 3 days from today.
3 days.
Within 3 days, steps.
2 weeks.
2 weeks, what? For taking a step, you are going to take fresh steps. That will be taken within how many days? Step will be taken within how many days?
Tomorrow we'll take step.
Okay, then within 3 days. Okay, list is matter after 2 weeks.
Okay.
Okay.
Item number 15 and 16.
2 weeks will be too early, I think, because you are going to take steps. It will be 3 weeks. Okay, list is matter after 3 weeks.
And my lord.
There is interim.
I think not there, Lordship.
What interim order was there? What interim order in the,
Interim was not there, Lordship.
the interim order passed earlier will continue till the next date of listing. Okay. Hmm. Yes.
Item number 15 and 16.
Hmm.
My lord, I'm appearing on behalf of OPADA, Standing Council for the SCB.
Okay.
My lord, as per the office notice, service among the respondent number 2 and 3 are still awaited.
Hmm. Ms. Somo, Lana Council for the petitioner is present. So, Mr.
Di Vangu,
appear on behalf of Mr.
OPADA,
Opada, Lanet,
SCB,
Standing Council,
SCB, for the SCB.
SCB. That is respondent number
2 and 3.
2 and 3. Staff. The service upon the office note dated 29/11/2025 reflect that the service upon the respondent. You are for respondent number?
My lord, I'm for the one SCB.
SCB is 1.
One.
One only, huh?
Yes.
He is. 2 and 3 is still awaited. So,
We will await.
okay, in view of the above, let this matter be listed after 2 weeks.
After vacation.
After vacation? Okay, after the ensuing
There is interim.
winter vacation stuff. The interim order passed earlier shall continue till the next date of listing. Okay.
Much.
Item number 17.
Yes.
So petitioner Lordship, they are keep on absent, Lordship. They.
No, what is
petitioner
this
Lordship.
criminal petition?
Yes, Lordship. So quashing the
None appears. None appears.
moreover, Lordship, this petition is not
None
one
appears.
petition, Lordship.
Okay.
So that respondent, they have to implement the respondent also, Lordship.
Not yet impleted.
Not Lordship.
Okay. None appears on behalf of the petitioner on call. For the none appears for the petitioner on call, staff. However, Ms. El Hage Lanet, additional PT, public prosecutor, is present on behalf of the state respondent staff.
Lordship, next occasion, Lordship, if they are not appearing, it may be dismissed, Lordship, because they are not appearing, Lordship.
Next date.
Yes, Lordship. On next date, if they will not appear, Lordship.
It will not, this case will not leave up to next date.
Otherwise, Lordship, it may be dismissed today also, Lordship, because they have not implemented the private, this complainant also, Lordship, because this is not a joint petition. And we have this case that we also called
What is
for.
the allegation?
Lordship,
Also,
not Lordship.
then This quashing petition,
Yes, Lordship, quashing petition.
not impleted the private
Yes,
respondent,
Lordship, because it's not a
Okay.
joint petition.
the, it appears that the petitioner, sorry. The record reveals that the petitioner remained absent for 3 consecutive days, and today also remain absent on call. The record further reveals that the petitioner has not implemented the informant as respondent in this case, despite of given sufficient opportunity to do so. In view of the above, it appears that the petitioner is no longer interested to pursue with the matter any further. Accordingly, this criminal petition is dismissed for non-prosecution.
Much obliged, Lordship.
Item number 18 and 19.
Be pleased, Your Lordship. So here in this item number 18, I am on behalf of Bolaram Das. So it's a MAG appeal. And IA is for implement application. Both are IA. Item number 19 also IA filed by the respondent and item number I filed by the applicant.
I filed by whom?
Item number 18 filed by the appellant for implement of new.
Okay, you are for the.
I am for the appellant in the item number 19, Your
Mhm.
Lordship. And respondent number 1,
What is this item number 19 is for?
and in the
No, item 18.
18, Your Lordship.
Okay. 18 is
I'm
for what?
appearing on behalf of respondent number 1 in the item number 18.
No, in 18, you are for respondent.
Yes, Your.
And 18, who is for the appellant or applicant? Boluram. You are for Boluram.
Yes, on behalf of Bolaram.
Okay. So this is application for implement.
Implement.
In 18, you are for respondent.
Yes, Your Honor. Yes, Your Lordship.
You have any objection?
Yes, I wish to file
Objection.
objection, Your Lordship.
Why?
That's because Your Lordship, the claimant died on 3/11/2023.
Okay. Mr. Then Mr. Udeka, Lana Council appearing on behalf of Mr. B.R. Das, Lana Council for the applicant. In 18, B.R. Das is for applicant.
Yes, my lord.
Okay. Mr.
SP Pugan.
H.P. Pukon, Land Council would appear on behalf of the
Respondent number 1.
respondent number 1 and prays for some time to file objection. The prayer is allowed. List this matter after
4 weeks, sure.
4 weeks. That is in 18, huh? And in 19,
19, Your Lordship, receive application.
19 who is
Condonation
for the-
application.
you are for the
Yes, Lordship.
applicant.
Yes.
What is this application for?
Application for condonation of delay, 198 days.
You have objection?
No objection, my
Okay. Heard Mr. H.P. Fukon, learned counsel for the applicant stroke appellant. This is condonation petition.
Yes, Lordship.
This interlocutory application has been filed under section 5 of the Limitation Act 1963, read with section 173, proviso of the Motor Vehicle Act 1988 for condoning the delay of 198 days, for praying for condonation of delay of 198 days in preferring the connected appeal filed against the judgment and award dated 8/8/2024, passed by the Learned Member Motor Accident Claims Tribunal, West Cameng District, Bomdila, in MSC case number 15/2022. Stop. Para. The ground for not preferring the connected appeal on time has been explained in paragraph. Which paragraph you have stated?
6, Your Honor.
Paragraph 6.
6, Your Honor.
Paragraph 6. Only 6
Yes, Your Honor.
of the application.
6, 7.
On perusal of the explanation given in the above paragraph, comma, this court is satisfied that the applicant stroke appellant was prevented by a sufficient cause in not preferring the connected appeal within the stipulated time. Stop. Moreover, Mr. Udeka, Learned Counsel, appearing on behalf of the respondent. You are for claimant?
Yes.
Stroke claimant has no objection in condoning the delay. Stop. Para. In view of the above, the delay of 198 days in 98 days in filing the connected appeal is hereby condoned. Stop. With the above, this IA stands allowed and disposed of.
Your Lordship, we have also
The-
filed stay of impugned judgment and order. In this.
Okay, that is in condonation of delay, huh? Then MACT make appeal has to be admitted first.
Lordship.
Then item, this make appeal number 9. See, you have, by this. So you are objecting the implement of the legal heir of the respondent. Then how do we go about? He is no more. Claimant is no more.
Claimant that before
Then
passing judgment,
What is that then? So you are adamant to pay the compensation to the person who is no more.
Sir, we have a criminal knowledge after the filing this I application.
Now, they are
Yes,
seeking
Lordship.
to replace the legal heirs of the deceased. The deceased whom you have imputed as a respondent is no more.
Lordship.
Then whom you are going to pay, even if you are directed to pay also?
Actually, Your Lordship, in this case, there is no such insurance policies. That's why we filed up preparing this appeal.
Now, even if it is admitted also, then the respondent is no more. The case abated in respect of the
Yes.
respondent, then whom will you pay? If you are directed to pay. If no stay is granted to you, whom will you pay?
Actually, there's a
Supposing this court refused
yes,
to grant
Lordship.
stay, you have to pay. Whom are you going to pay unless you allow the legal heir to replace their deceased father or what? Who? That can be
Daughter.
allowed, I think. We'll grant you a stay,
Yes,
but then that can be allowed. Impleadment can be allowed. Impleadment, what will do? He is no more.
yes,
Yes.
Lordship.
The person is no more. By any means, he has to be replaced or impleaded. It's not a case of delay.
Yes, Lordship.
He is no more.
Firstly,
They are not filing any delay condemnation petition where you can file objection. They are only praying for replacement or impleadment of the legal heirs of the deceased. Lawful legal heirs.
actually, we had not got all the annexers. That's why we
What annexer?
in the I petition.
See, one way you are praying for admission of this appeal. It cannot be admitted unless there is a party respondent.
Lord.
The respondent is no more. They want to come as a respondent in place of their father. If that is allowed, then only this make appeal
Yes,
can be admitted, and then your prayer for the stay of the operation of the impugn order can be stayed. But this cannot be admitted unless there is a party. The party is no more. The party who wanted to come
Yes, Your Lord.
or to be impleaded, you are objecting. Then in that case, it cannot proceed.
Yes, ma'am.
How do we proceed without any respondent?
This is where our claimant was our mother, we are the daughter.
See? What objection? Think about that. Okay, as prayed for by the Land Council for the appellant, please this matter.
Yes.
When?
4
After
weeks.
2 weeks.
After
Four,
2
4 weeks. Lord.
Hmm?
4 weeks, Lordship.
4 weeks.
Yes.
Only to think whether to allow to implead.
Yes, sir.
It will take 4 weeks.
2 weeks enough.
You can just go out and
Actually,
ask your senior
Lordship.
or whosoever, the client.
Lordship, before going
1
to
minute.
the make appeal, then after
After, okay.
then the
After 4 weeks.
okay.
After 4 weeks?
Yeah,
Okay, after
no
4
problem.
weeks. Okay.
Okay.
No stay. You can file.
Yes, yes. Of luck.
Matter number 23.
May I please, your lordship?
Yes.
My lord, regarding item number 23, 24, and 26.
Mhm.
Here is same appellant, my lord. Now, as per instruction of the appellant, my lord, I want to withdraw this appeal, my lord. My lord, this is a MSc appeal, my lord, against
Okay.
the award, my
Okay.
past district and session judge, my lord, in MSc case number, my lord, so and so. Now, in that case, award has been granted against me. So I have
Okay.
the appellant has challenged that 3 cases in this item number 23, 24, and 26. Now,
Okay.
my instruction, my lord, during pendency of this case, already the appellant has paid the money to the my lord victim's family.
Okay.
So
Okay.
the execution has
Already
been
paid.
withdrawn.
Then in that case, it has become infractus.
Yes, yes, my lord, yes.
Okay, Mr.
K. Singha, my lord.
K. Singha, learned counsel for the applicant. Applicant, you are also for
Appellant.
the appellant.
Yes.
Okay, applicant, appellant. IA is for what?
IA is for delay condemnation. Delay was there, my lord.
Okay, okay. Some is that during the pendency of this IA and the appeal, the respondent insurance company has already paid.
No, my lord. Here, the payment is directed to made to the owner of the vehicle. Now I am the owner of the vehicle, my lord.
Okay.
So-
Owner already paid.
Yes, but the appellant already paid.
Okay, the owner of the vehicle has already paid the compensation, awarded compensation amount to the
Yes, yes.
respondent claimant. Therefore, the matter has become infructuous. And he has in instruction to withdraw this IA as well as the appeal. Item number 23, 24, 25.
No, I did not 23, 24, and 26, my lord.
Okay, not 25.
Not 25.
Okay, 23, 24, and 25, 6. And we have the above, the prayer is allowed. The IA as well as the MAC appeal stands dismissed as withdrawn. Okay. So then mention this IA 23, 24, and 26. Okay.
Your Lordship,
Okay. Yes.
kindly reflect the name of, I am appearing for respondent number 2.
Okay, Mr. HP Phukan, learned counsel for above, before dismissal. HP Phukan, learned counsel for the respondent number
2.
2 is
In
also
both-
present. Okay.
Both 3 cases.
And Your Lordship, in item number 24 and 26, I am for respondent number 1.
Okay, and Mr.
J.
J. Siri for respondent number 1. Okay. They have no objection, Okay. Yes, what about
Obliged.
this 25?
Highly obliged.
Okay, what about this 25?
Item number 25.
Obliged.
Okay, it's different.
Different method.
Okay. Yes. Mr. Porsi,
Yes, Lordship.
what is this case
Lordship, this is appeal
against?
against the judgment and order dated 29/05 of 2022.
So,
24, passed by the learned,
convicted
yes,
for what? Where is it?
the Lordship, in paper book.
$376.
Yes. Lordship, in paper book, judgment is
Marrow and wife, and he may be shown mercy.
is 52. $52 to page 77 euros.
Sentence of rigorous imprisonment for 10 years
Yes, Lordship.
and for fine of rupees 10,000 for offense under section 376 IPC.
Yes.
Okay. So,
Your Lordship, in this case, the convict person was convicted only on the sole testimony of the victim lady.
okay, what is wrong in that?
Wrong is that, Your Lordship, our statement is not constant, and there is no, the statement of the victim lady is not trustworthy. So that is our contention, that her statement is not trustworthy. So only on the basis of her testimony,
Why the her statement is not trustworthy?
her statement is not trustworthy because in FIR, she stated something else, and 164 that is different. And exact date and time of offense is not disclosed in the FIR. So that her statement cannot be relied. It is not trustworthy.
What about the medical examination report?
Medical examination report was completely against the prosecution. There is nothing against the convict person. The medical report is. It is only on the testimony of the victim lady.
That is enough. That should be enough. And who else will see the commission of 376?
Yes,
Who else you expect to see the
Your
commission of
Lordship,
376?
there is a, I do agree that there is a catena of judgment of the apex court also, and
Yes, in
our
all the
court
cases,
also.
in all the cases, 376 cases, it is only the evidence and the statement of the victim which led to to conviction.
Yes, that is there, Your.
Because
If
because in such cases, the perpetrator, the accused ensures that there is no one to see. That is why 376. Otherwise, how the 376 will make out?
Yes, that is there, Your Lordship.
Hmm.
But in this, in present case, the fact and circumstances is different, Your Lordship.
Anyway, so today at 2, I think we will be sitting in the DB,
Yes, Lordship.
and probably today it will be difficult.
And moreover, Lordship, LAC of this appeal, Lordship, he is also absent today, Lordship.
LAC, who is
Uh,
LAC?
Christina Eding, Lordship.
Yes.
For victim, Lordship.
Christina? Who?
Christina Eding, he is a LAC for
Okay,
victim.
Erin.
Yes, Lordship. So it fixed
Christina
date,
Eding.
fixed date may be given.
She represent the victim.
Yes, Lordship.
Okay.
Your Lordship.
Why she is absent?
I don't know, Lordship. Today he is not there in court.
Why we? Oh, okay. Mr.
Lordship,
Counsel for the appellant. is present.
one
Yes.
IA is there.
L.
Since
Hage,
IA is pending.
Learned additional PP is also present. However, Miss Christina.
Christina Eding, she Eding,
Christina.
Christina Eding.
Christina
Erin Learned LAC for the private respondent he is absent. So when do you want?
Your Lordship, in that case, IA may be considered, Your Lordship.
When this was filed?
Lordship, it was
We'll have
filed-
hearing. So what we'll do is we'll dispose of how long he has been inside?
He has been inside in the more than 1 year, 6 months.
1 year, 6 months.
Yes.
The conviction is for 10 years.
So in that case, you're not, IA may be considered.
Since paper book is also ready, we'll dispose of the entire matter. Okay, so when do you want? 2
In that
weeks?
case, after 2 weeks, you are.
Okay. Let this matter be listed after 2 weeks. Okay. It's done.
Single benches.
Lordship, fixed date may be given, Lordship, so that other party will inform.
Okay, then
Yes.
when?
In that case, you.
After 2 weeks would be
23rd December.
23rd December.
Yes, it was the hearing date.
Okay, 23rd December. Let's wait for that.
Applies.